AIETAR 2026 is structured in 6 parts, 3 schedules and 2 appended instruments. Understanding the architecture first prevents you from treating individual rules in isolation. Context is everything. Part 1 is general. Part 2 is institutional structure, including the chief adjudicator. Part 3 covers intake and panel composition. Part 4 is the engine. It contains the 3 primary tracks, the evidence rules, and the indisputable record. Part 5 handles costs and representation. Part 6 is the Electoral Supervisory Review Tribunal for Quality Assurance. The 3 schedules cover fees and conduct. Form E1 and the mandatory legal notice complete the framework. Learn the architecture before the detail to master AIETAR 2026. Rule 4 addresses the constitutional status of an AIETAR tribunal directly. It provides that a tribunal derives its adjudicative authority from the same source as the courts. This is the sovereign power delegated by the people of Kenya to state organs under Article 1(3)(c). Independent tribunals and courts are both state organs drawing from this same source. This matters operationally because it determines how you understand your own authority. You are not an arbitrator or mediator. You are a constitutional officer exercising delegated sovereign authority. You are subject to the supervisory jurisdiction of the High Court under Article 165 on questions of legality and procedural propriety, but not subject to appellate jurisdiction. No court reviews your findings of fact. No court substitutes its own view of the merits. The High Court supervises, it does not retry. Understanding Rule 4 ensures you exercise your authority with the correct constitutional perspective. You are a state organ. Rule 3(2) sets out the scope of AIETAR jurisdiction. Sub-Rule C is the most important provision for practical purposes. It makes explicit that AIETAR jurisdiction is parallel to and does not displace the jurisdiction of the Commission, the PPDT, or any court. We covered the constitutional basis for this in previous modules. Rule 3(2)(c) translates that analysis into operational rule language. Rule 3(4) provides that every dispute is resolved exclusively by unilateral adjudication. Contractual consensual arbitration is completely barred from these proceedings. This is a structural distinction from AITAR 2026, which offers both adjudication and arbitration. AIETAR is a single-track instrument. All proceedings follow the adjudication highway. Understanding this scope is fundamental to correct practice. Rule 5(3) states the guiding principle for the SRT that applies equally to all AIETAR proceedings. The internal review jurisdiction exercised by the SRT is strictly supervisory and completely devoid of appellate jurisdiction. The SRT shall only examine the primary proceedings to ensure compliance with Article 47 and the FAAA. It shall never re-evaluate factual findings or reweigh evidence. This principle governs not only the SRT's review, but how you, as primary adjudicator, conduct your proceedings. Every step is a potential ground of review. The FAA Act Section 7 grounds are the constitutional checklist against which every step of every AIETAR proceeding will be measured. Apply them as you go. Maintain procedural propriety from the start. The architecture of AIETAR depends on it. This concludes the overview of AIETAR architecture.